Hello, this is Matt Valliere from the Institute for Patients' Rights. I'm here with Ernie Galvan and Mike Bean, our lawyers in the case against the state of California to overturn the assisted suicide law here. We're at the Ninth Circuit Court of Appeals, and we just came out of the hearing at which Ernie so beautifully argued our case. Ernie, could you just give a little bit of a synopsis of what happened today, the sorts of questions that the judges asked you, and how you were able to respond on our behalf?
I think the panel of Ninth Circuit judges were very engaged in specific issues about how the case can move forward. So that's always a good sign if they want to talk about the future of your case, especially a case like this where the lower court terminated the case prematurely. It's nice to get future-oriented questions. So
fair.
I'm hopeful in that regard that they keep up that orientation.
So what were some of the specific questions that they asked you that you felt were really key to today's hearing?
Well, they were concerned about the standing, in other words, whether our organizations, whether Communities Actively Living, Independent and Free, United Spinal, and Institute for Patients' Rights, and Not Dead Yet, whether they had enough stake in the litigation for it to proceed in their name. Mm-hmm. And so it's been a lot of ferment in the law, nothing to do with assisted suicide, but having to do with when organizations can sue.
Right.
And they were concerned about how that's going to affect this case. On the merits of our case, we got very probing questions from Judge Mendoza about what it means to be terminally ill within the statute, and whether our plaintiff, Ingrid Tischer, has ever been considered terminally ill. And I tried to refocus him on the way the statute allows allows a doctor to declare you terminally ill. Right. In all kinds of circumstances that are not intuitive to someone like an appellate judge who's trying to figure out how the statute works. For example, you could undergo dehydration and malnutrition deliberately in order to make yourself terminal. Right. And we know that doctors will declare you terminal on that basis, even if you had no underlying illness. Although the example I used with the judge was not that one, but the example of anorexia, because we know we have cases in Colorado and elsewhere where people with anorexia are prescribed lethal medications.
In fact, here in California, there are confirmed cases of that.
Indeed.
Yeah.
And so that's, Judge Mendoza's concerns are critical for these cases because it's very easy for judges to say that our individual plaintiffs, because they're not at death's door at this moment, don't have a personal stake in this dispute.
Right.
And that's what the judge here in Los Angeles said about Lonnie Van Hook and Ingrid Tischer. And I'm glad I got questions from Judge Mendoza about that, and I think the other judges were paying close attention because we really need to move minds on that issue of personal stake.
Yeah, it's important too. It's like, obviously, we've lost, out of the organizational plaintiffs, we've lost Lily Beth, we've lost Diane Coleman. These are two lionesses of the disability rights movements who they were leading organizations that were organizational plaintiffs. We also lost Lonnie Van Hook in all of this. He was one of the individual plaintiffs that we were claiming had standing because of being at risk in this exact circumstance. And so it's the catch-22 of the old Lee decision that you don't have standing unless you're actively dying, and if you are actively dying, you're probably going to be dead by the time we're done this case. So you can't have standing that way either. But in our situation, we have to continue showing that whether this person is definitely, with no questions asked, going to pass away, or they qualify under the murky definitions of terminal under the statute here in California, that all people with disabilities, whether in the one group or the other, are at risk of discrimination, and that's the real harm done here.
Yes, and there's the impact on medical care, even just your ordinary medical care.
Right.
As we said in our complaint about Ingrid Tischer, her access to ordinary medical care, rehabilitative services, is hindered by physicians' attitudes that really death should be the next step for her, not rehabilitation. And that we need to show the link between the physician-assisted suicide regime and that attitude in medical care.
Yeah.
And I was very happy that some of the advocates who came out for the hearing helped us with their own personal stories after the hearing, and sort of reinforcing that link, which is it's a very hard link to get people to understand. But I think it's important to show why federal disability laws are on a collision course with physician-assisted suicide. It's the distortion that physician-assisted suicide works in the medical care system, harms people throughout all their encounters with the system.
Right. And that, I mean, I think some of what is difficult to break through in the kind of societal mores of our times is that all people who have a life-threatening disability, whether it's cancer or anorexia or ALS, people don't often think of the stage 4 metastatic cancer patient as a person with disabilities under the ADA, and that's some of the threshold we need to break through to get over. It's a hurdle in people's consciousness that they too should be protected under federal anti-discrimination law.
Yes, and the ADA is meant to protect people in that situation where your bodily functions are deteriorating and your ability to engage in the activities of daily living are impacted, and that's true for people with medical conditions who have not considered themselves persons with disabilities before.
Right.
And it's very dangerous to carve them out, and especially in a medical regime, because if you go all the way back to the history of the disability rights movement, it's medicalization that people fought against. It's the idea that your role in society is to be a patient. It's not to be a person who works and plays and has a full life. And this physician-assisted suicide regime is kind of medicalization on steroids, in that the patient becomes an opportunity for experimentation with this new form of cheap end-of-life care.
Yeah.
It's tragic when we have so much good end-of-life care now that rather than focus on comfort and palliation, that we would experiment with hastening death with poison. Yeah. That's exactly the wrong response.
I find it really interesting that the state's council tried to focus in on that nobody's being forced to do this thing, and the state doesn't have some kind of responsibility to people who opt into this additional choice, as she put it. It seemed to me like there was almost like this obtuse idea that there's no pressure on people, that everyone just makes these free and autonomous choices. Mike, we've talked a lot about this. What are we claiming in the lawsuit that kind of brings attention to how people are pressured and how decisions are made in a medical setting, and why we see this as discrimination in the light of almost like self-inflicted internalized ableism and discrimination on oneself, but also this idea that these people, the people who are opting to kill themselves with non-assisted suicide, they too want to die, and yet we force them in every other circumstance to receive suicide prevention care. And so why is it that the state tried to claim that this is somehow different than that? It seems like they're both the exact same thing.
I mean, I agree with you, of course. I think that this idea that there's autonomy and choice, and what this law does is raise that up for these people who are in a vulnerable state. We're going to give you this extra special choice that we don't give anyone else, is a disingenuous. In other words, it's false to say that people are free and unencumbered and considering all their options, when the reality is that people are in a very traumatic, difficult situation when they have facing maybe the end of treatment, for something they've been treating or facing increased pain, and they to meet with a doctor, probably with your loved ones, your family, and hear that this is on the table. Either someone's going to have to figure out how to get this patient home from the hospital, where they're going to live, who's going to take care of them, how are you going to get services,
Right.
and no one's not clear what the waiting list is to get eligibility for X or Y or Z that you might need for home health care, or for a hospital bed, or for a wheelchair, or for an aide, or to get into or get hospice, or does your hospice have services in your area?
Right.
But then to be told that you have this option, totally free will, but when people don't want to feel that they're a burden on their family, where they don't know where the money is going to come from if the insurance doesn't come through, or the federal or the health insurance programs or support services don't come through, is telling a person at this moment that their inclination to just end things, to commit suicide, is appropriate and should be supported. It's a reasonable choice given your circumstances. Puts them into this other world and treats them in a different way than any other patient would be and should be. If you were in a different state without this law, in the exact same situation, the doctors would know what to do.
Yeah.
They would discuss with you your options.
Totally.
They would suggest people to meet with. They would meet with the family about services and programs. They would ask, do you have a spiritual connection that you can get support from? Do you have a congregation, a community? They would work on those things. Having this on the table, and where the doctor is told, this is state law here, you have a duty, isn't this one of my duties to provide all the options? This is one of the options.
And that's kind of like some of what I was just kind of shocked by when opposing counsel brought up the voluntary nature of this, saying like, well, giving these people this additional choice is not the state, pushing them in a direction, and it's not forced. That there's no forcing of anything, either for suicide prevention or for suicide help, but yet those people who are dying by unassisted suicide, they too want to kill themselves on some level,
right.
And they many don't want to die, but they feel like there's no other way out. In the same way that many don't want to die, who try to get assisted suicide, but they don't see any other way out.
Right.
And so it was just very interesting to me that she would make it almost as though she didn't at all look at the fact that we in medical care, if somebody expresses a desire to harm or kill themselves, whether they want to kill themselves with every fiber of their being, that we stop them.
Yeah. As
a society, we stop them, and that is non-consensual care that we provide to people every single day. Whatever you think about forced treatment for people with mental health disabilities, the fact that we do everything we can to stop some people from killing themselves and not others seems to me like
there's a continuum here.
Yeah.
So if the continuum has, involuntary hospitalization, we're going to call a cop and they're going to bring you over.
Right.
That's one extreme.
Right.
And then there's this tremendous area where you're working with a person, you're trying to find the right person to reach them, you're bringing them things, you're talking to them, okay? And then we have this law. I agree with you. Suicide is a good choice for you. I'm going to write you a prescription, and I will help you get the medications, and your family can help you mix them. Like this is so different, and there's a tremendous area in between, arresting somebody for being suicidal and locking them up or bringing them to an ER, which of course is the law in California.
Right.
But again, that's extreme, and what we really, good medical care doesn't need to go there, right?
Yeah.
And I think the other thing that our case is based on is, rather than focusing on this law, focusing on suicide prevention. What is good suicide prevention? Mm-hmm. Okay. The people who have a chance of surviving are the ones that get to see a doctor. Mm. Okay. When somebody is in distress, does somebody actually activate? Does the nurse or the caregiver or the family member or the friend bring them to a doctor or tell a doctor about it? Those are the people that can survive suicide.
Right.
Suicidal ideations and thoughts. Here, we're perverting that option for saving people, because these people are getting to a doctor, but they're getting the opposite of
outcome.
care.
Yeah.
So I think she's wrong when she says this is all voluntary and there is no steering. Even by the way the law operates, it is steering, because again, these decisions are perverted by the law. The doctor is told to do something different. Again, most doctors in California, we think it's about 97%, do not participate. So when you find a doctor from this list of doctors that participate, this is their job. This is their specialty. And so you go to them and say, these are all the things going on in my life. I'm pretty miserable. I want to end my life. Can you help me? It's like, that's my job.
Yeah. Now that we're at the Ninth Circuit, where could this go from here?
Well, what we would like is for it to go back to the trial court in Los Angeles with instructions to allow the case to move forward so that we can prove what we alleged,
Right.
which was the way that this system violates disability rights and constitutional rights.
Excellent. Why did the judges, do you think, focus so heavily on this other case that's yet to be determined, this Arizona Alliance case?
Well, it's good and bad. You want me to start with the good or the bad?
Both.
The judge in Los Angeles ruled that our organizations have standing, that our organizations have enough of a stake in the outcome of the case that they can proceed.
Right.
The state has challenged whether that's correct. The state is telling these judges in the Ninth Circuit, no, United Spinal and the other organizations do not have enough of a direct stake in this.
Okay.
And so that question, when does an organization have enough of a stake to bring a lawsuit, is really unsettled right now in the law because of some cases from the U.S. Supreme Court and the Ninth Circuit.
Okay.
Judge Nguyen, who was on this panel, was very, very instrumental in one of those cases that unsettled the law. And just last week it got even more unsettled, and so she was probing as to whether the question of United Spinal's and the other organizations standing to bring the lawsuit, whether they have enough of a stake to litigate about the case, whether that should wait until the law in the Ninth Circuit gets a little more settled, which it may get in the next 6 months or so. My answer was no, it should not wait, because I would like our case to move forward,
Right.
because it's about justice now. But,
So we could be waiting until that case is decided, and then they would decide on our case, hypothetically.
that could be what happened. I think that
think it's
Judge
likely.
Nguyen was leaning that way.
Okay.
And
And
she's kind of the elder on this panel, so
Okay.
the other two may go with her.
And then that, say it went our way, where they don't wait for that, what are the other possible outcomes here?
Well, one possible outcome is that this panel goes with my argument, which is that no matter how the dust settles with the unsettled law on organization standing, we win.
Yep.
Our organizations have standing. And what we allege violates disability law does violate disability law. Then we go back to the
the
trial
lower
court and we prove our case.
With Judge Andrea Rocha.
Yes,
Okay.
with the same judge, and we prove our case. Another possible outcome is these judges in the Ninth Circuit could go our way about the standing of United Spinal, but but go against us and affirm Judge Andre Rocha on the question of whether we have a case.
Got it.
Because the trial court said we don't have a case because the way he wrote the opinion, disability law is here, assisted suicide is there, and they don't touch each other.
Right.
So we need the Ninth Circuit to take a different view of that
Yes.
and instruct the trial judge to take a different view of that.
So if they go with the latter and they agree with Judge Andre Rocha and the state, then that case is dismissed, and our only option would be to appeal to the Supreme Court.
There's a step in between.
Okay.
We argued today before a 3-judge panel of the Ninth Circuit. If this goes against us, we can ask a larger panel of the Ninth Circuit, an en banc panel.
Got it.
Panel, which would be 13 or 11 judges, to sit and review what this 3-judge panel did, and then we could go to the Supreme Court, or we could go directly to the Supreme Court.
Got it.
In both of those cases are not, both of those recourses for us are not guaranteed. And for a fuller Ninth Circuit panel, they have to agree to take it.
Right.
And for the Supreme Court, we know they have to agree to take it, and they only take something like 70 cases per year.
Yeah.
So.
Well, that's all kind of moving the case forward. Hopefully we'll prevail today into the future with their judgment, and we'll be arguing this case later in the year before Judge Andre Rocha. Thank you so much for all your hard work on this, you guys. This has been very edifying to see both the disability community come out in support of us, but also to see your amazing hard work as lawyers. We're so grateful to have you representing us, so thank you.